All right, good morning and thank you all for joining us today. I'm Alvaro Santos, Professor of Law at Georgetown University and Faculty Director of CAROLA, our Center for the Advancement of the Rule of Law in the Americas. Welcome to the third webinar of our fall series, The Americas in Times of COVID-19. We have a session today called The New Labor Regime under USMCA, and we have a wonderful lineup of speakers who I will introduce in a moment. In this session, we would like to discuss what the new labor provisions of the United States-Mexico-Canada agreement look like and what their potential benefits and downsides may be. For benefit of the audience, very briefly, the USMCA introduced important changes in terms of labor mechanisms for enforcement of workers' rights. There is a chapter 23, which contains new labor provisions. There's also an annex of that labor chapter in which Mexico committed to do an overhaul of its labor law and its labor institutions, which has already passed into law and is in the process of implementing. And we also have a protocol of amendment that instituted new rapid response panels with a speedier form of dispute settlement mechanism that also includes on-site verification at firms and factories. And so we're going to talk about all of this, and some of the questions that we are going to discuss are: in what ways is this new model different from the NAFTA agreement that it renegotiated? And also, in what ways is this different or has certain innovations when compared to the traditional trade labor model that we had seen over the years and that culminated in the Trans-Pacific Partnership Agreement, or now the new Comprehensive and Progressive Trans-Pacific Partnership. We also want to know how these rapid response panels are supposed to operate. And finally, we want to get a better sense of what are the likely effects or consequences of these new labor enforcement provisions on US workers and companies, and also importantly on Mexican workers and companies. So these are all very important questions. It's a new labor regime, one that has created a lot of expectation and enthusiasm as well, and obviously some concerns too. This is an agreement that the labor movement in the United States supported by and large, and that basically got also the support of both Democrats and Republicans, something that previous trade agreements have not gotten in such big numbers. And so there's a lot of interest in these new mechanisms, and the purpose of the panel is to have people who have been deeply involved in the trade and labor questions, and also in the institution of this new agreement, in the labor reform in Mexico, to tell us what they think and how they see this unfolding. So let me now introduce the speakers that we're really delighted to welcome, and I'll introduce them in the order that they will speak. Each panelist, or each speaker, will have about 10 minutes to make an initial presentation, and then after that, we'll open it up for questions from you, from the audience. You can ask those questions in the Q&A function of the Zoom, and I'll then pitch those questions to our speakers. So first we have Professor Lance Compa, who has well-known and very renowned career. He recently retired from Cornell University School of Industrial and Labor Relations in New York, in Ithaca, New York, where he taught for many years labor law and international labor rights. Before joining Cornell, Professor Compa directed labor law research at the NAFTA Commission for Labor Cooperation. And prior to that, he taught labor law, employment law, and international labor rights as a visiting lecturer at Yale Law School and the Yale Law School of Management. He also practiced international labor law for unions and human rights organizations in Washington, D.C. He's written widely on trade unions, international labor rights, and other topics for a variety of law reviews, journals of general interest, magazines, and newspapers. He's also a lead author of the casebook International and Transnational Labor Law Cases and Materials. He wrote the 2010 Human Rights Watch report, A Strange Case, Violations of Workers' Freedom of Association in the United States by European Multinational Corporations. And he's also the author of the 2005 Human Rights Watch report, Blood, Sweat, and Fear, Workers' Rights in U.S. Meat and Poultry Plants, among several other reports that he is the author of. In addition, he's also conducted workers' rights investigations and reports on Cambodia, Chile, China, Haiti, Guatemala, Mexico, Sri Lanka, and other developing countries. He serves on 2 federal advisory committees related to his research and teaching, which are the Department of Labor's National Advisory Committee for Labor Provisions of Free Trade Agreements and the State Department's Stakeholder Advisory Board on the U.S. National Contact Point for the Organization of Economic Cooperation and Development. Thank you very much for joining us today, Lance. Welcome.
Thank you.
Next, we have Katherine Tai, who is the Chief Trade Counsel and Trade Subcommittee Staff Director for the Committee on Ways and Means of the U.S. House of Representatives. She advised the committee's Democrats and the Democratic Caucus Working Group in the 2019 renegotiation on the U.S.-Mexico-Canada agreement with the Trump administration, which resulted in historic levels of Democratic and bipartisan congressional support for the USMCA Implementation Act. Katherine came to the committee in 2014 from the USTR's Office of the General Counsel, where she served as Chief Counsel for China Trade Enforcement, with responsibility for the development and litigation of US disputes against China at the World Trade Organization. Before joining USTR, she worked in the international trade departments in several Washington, D.C. law firms, and from 1996 to 1998, she lived and worked in Guangzhou, China, teaching English at Songshan University as a Yale China Fellow. Welcome, Katherine. Thank you for joining us today. I also want to make clear that we have agreed with Katherine that her remarks today are off the record and not for attribution, so we ask our participants to please honor this agreement. Next, we have Patricia Juan Pineda, who is a Mexican labor lawyer, a human rights lawyer, and a feminist. She is the legal advisor of the Frente Auténtico del Trabajo, or Authentic Labor Front, an association of independent unions who has advocated for labor law reform for many years. She has many years of experience representing the interests of workers and independent unions, has written several academic articles, and participated in numerous workshops and conferences. She has participated in the development of strategic litigation and in the advice and presentation of many cases at the national and international level. She's also presented several reports before international organizations like the International Labor Organization and the Commission and the Inter-American Court of Human Rights. She's participated in the formation and capacity building of many staff and also of union members and workers. And she has also wide experience in participating in collective bargaining agreements and representing the interests of workers and of women. Welcome, Patricia. It's a delight to have you here. And last but not least, we have Jeffrey Vogt, who is the Rule of Law Director of the Solidarity Center at the AFL-CIO, the American Federation of Labor and Congress of Industrial Organizations. Prior to his Solidarity Center tenure, he was the legal director of the International Trade Union Confederation, or ITUC, from 2011 to 2016, where he coordinated the organization's legal advocacy before the International Labor Organization and other international institutions, advised trade unions on labor law and policy, and assisted in litigation before national and international tribunals. He has published and spoken frequently on international labor law and trade and labor standards, and he has also provided testimony before legislators of the United States, Canada, and the European Union. He served as the AFL-CIO Deputy International Department Director and was the AFL-CIO Global Economic Policy Specialist. He previously represented domestic and foreign trade unions in litigation in US state and federal courts. So as you can see, wonderful speakers with a wide range of experience in different areas who bring different perspectives to the table today. And so without further ado, Lance, please, you have the floor.
Okay, hello everyone, and thanks to Alvaro and the CAROLA team for organizing this important event. I'm starting things off addressing the question, how did we get here? Before turning to our other panelists for a closer look at the new US-Mexico-Canada trade agreement, the USMCA. Although remember that in Canada, it's the Canada-US-Mexico agreement, CUSMA. And in Mexico, it's the Mexico-US-Canada Treaty, MEC. Our trading partners don't want to concede that the United States is first in line. We're nearing the end of a presidential campaign now. Let's go back to the same time in the fall of 1992, when Bill Clinton was running against George Bush, the father. Bush had just negotiated NAFTA with Mexico and Canada, but the agreement was not yet submitted to Congress for ratification. It was a purely commercial agreement with nothing substantive about labor standards or environmental protection. Clinton was under pressure from labor and environmental activists and advocates to repudiate NAFTA, but he was also under pressure from his business supporters to embrace it, to lock in the neoliberal economic reforms that Mexico had implemented in the 1980s. Clinton threaded the needle. He would support NAFTA, but only with new supplemental agreements on labor and the environment. When he won the election, Canada and Mexico agreed to negotiate the side agreements. They really didn't have much choice. Clinton had to deliver these agreements, and Mexico and Canada wanted the commercial benefits of NAFTA. Now, I leave aside the environmental agreement, which is outside my area of work, but I am familiar with the North American Agreement on Labor Cooperation, the NAALC or NALC, NAFTA's labor side agreement. The NALC was an amalgam of clashing proposals and interests with many idiosyncrasies and flaws. But whatever its shortcomings, the NAFTA labor agreement hardwired trade labor linkage into US trade policy, reflected in successive Trade Promotion Authority legislation and in all the trade agreements that followed the NAFTA, with Jordan, Central America, Peru, Korea, Colombia, and others, and including the TPP, which we may revisit at some point. It also influenced trade agreements negotiated by Canada and the European Union. The WTO has always rejected the social clause, as it's sometimes called, but member countries forged ahead with labor provisions in trade agreements. These provisions had varying contents and effects, but they were always part of the deal. The NELC contained 11 so-called labor principles on freedom of association, forced and child labor, discrimination, wages and hours, health and safety, and migrant worker protections. But these labor principles were free-floating, as if they had been invented by US negotiators at the table. They were not anchored in international standards developed by the ILO, the authoritative global institution on labor norms. The NELC had one central obligation to which governments committed themselves: the effective enforcement of national labor law. They retained full sovereignty to make the law as each saw fit, without conforming to international standards. A complaint under the agreement had to argue that a party failed to effectively enforce its national labor law, not that it violated international standards. The NELC also created a somewhat counterintuitive cross-border labor mechanism, or complaint mechanism, cross-border complaint mechanism. You had to cross the border to file a complaint. So if the events giving rise to a complaint occurred in Mexico, workers and unions and their advocates had to file the complaint with the Labor Department of the United States or Canada, who would review the Mexican government's application of national law to the circumstances that prompted the complaint. Advocates filed more than 40 complaints under the NELC, about half against Mexico and the rest divided between the United States and Canada. Many of the cases in Mexico were handled in conjunction with the FAT, the Authentic Workers Front, the union that Patricia represents. Many of the Mexico cases challenged what is called the protection union system, a long entrenched practice of companies choosing their union rather than workers choosing their union. So it protected companies against having a real union. That's why it's called the protection union system. Now, after this initial filing, the government receiving the complaint took control of the process. The first stage involved ministerial consultations, and most complaints reached this stage. But while the NELC also allowed for a complaining government to advance the matter to an independent review panel, and then to dispute resolution and arbitration that could result in fines or trade sanctions, not a single complaint ever advanced to these higher stages. It appears that the three governments had a mutual non-aggression pact, ending every case with ministerial consultations that resulted in soft outcomes like research programs and outreach projects, nothing that smacked of hard enforcement. Now, despite these limitations, advocates found many ways to advance their interests by creative use of the complaint mechanism. For example, one case involved widespread mandatory pregnancy testing in the maquiladora factories along the US-Mexican border. Nothing in the NELC could order employers to stop these practices or make the Mexican government adopt any law to address it. But widely publicized public hearings and related media campaigning and cross-border collaboration between unions and feminist organizations and human rights organizations succeeded in shaming most of the big name companies in the maquiladora region into halting those tests. Working together on NELC cases also helped create a tri-national network of advocates who found many other opportunities to collaborate and to support each other in organizing and collective bargaining struggles. Experience under the NELC helped advocates identify its shortcomings and have Congress address them in TPA legislation and USTR to address them in future trade agreements. So now, labor chapters in trade agreements are part of the overall agreement, not a side agreement, suggesting it's an afterthought. Labor standards in post-NAFTA trade agreements are now anchored in the ILO's 1998 Core Labor Standards Declaration. Effective enforcement of national law is still the central obligation, but now national law has to be consistent with ILO core standards, not only in writing, but in practice as well. And trade sanctions are available in the dispute resolution process. Lessons of the NALC and post-NALC trade agreements informed negotiation of the new North American agreement, the USMCA. Many on the USTR and Labor Department teams involved in USMCA negotiations were also involved in those earlier agreements. And the Democrats taking control of the House of Representatives in 2018 also led to farther reaching labor provisions, since the Democrats could withhold ratification of the agreement unless its labor provisions were strengthened. One of the main problems with the complaint mechanism remains. Unions and labor rights advocacy groups can only submit a petition to a government, asking the government to file a formal complaint against a trading partner. But after that, the government that receives the petition is in control over whether to file a complaint at all. And if it does, how far the complaint will go in the dispute resolution process. There is no right of appeal by the petitioning labor advocates themselves. Will any complaint under the USMCA ever go to dispute resolution and arbitration, or to the rapid response panel under the new clause creating the rapid response system in the USMCA? Will the new labor law reforms adopted by Mexico put an end to the protection union system? But now I'm crossing into areas that will be addressed by our next panelists. So I'll stop here and look forward to the questions and discussion to follow.
Thank you very much, Lance. And that's a great segue. So now I'm going to ask Katherine Tai to take the mic. And for those of you who just joined us, let me just remind you that Katherine's remarks are off the record and not for attribution. Thank you.
Thank you so much, Alvaro. I'm really delighted to be on this panel. I'm very honored to be on this panel with the experts here, many of whom I have heard about, some of whom I've worked with, but this is really an all-star panel on this topic. This is also really an all-star topic to be discussing. This is I think one of the most interesting developments in trade policy in the US, certainly maybe for North America, over the past 4 years. And I think that it is worth pausing to consider that given the unpopularity of the NAFTA with our current president and with my bosses, the House Democrats, over many, many years, that we have just come through a number of years of turmoil over trying to address the discontents around NAFTA in a way that has resulted in a renewal of a trade agreement between these three countries. When the president talked about renegotiating NAFTA, it was really in the context of a desire to either withdraw from the NAFTA or to renegotiate it. And the call for renegotiation didn't just start with President Trump. It actually started many years ago. And my memory goes back to the campaign of President Obama on the campaign trail, addressing the discontents around NAFTA and committing to renegotiate it. And I think that if you look at the Obama record, the negotiation of the Trans-Pacific Partnership, the TPP, which included the US, Canada, and Mexico, can be seen as one way of renegotiating the NAFTA, although the TPP would have, as it was envisioned, existed side by side with the NAFTA. In the Trump administration, the attempts by this administration, Ambassador Lighthizer, was to take the existing NAFTA and to convert it into something new, always under the threat of getting rid of the agreement in total. I think it's useful to consider where we've come from because if we chart the renegotiation of the NAFTA and its transformation into the USMCA, I think it's important to take the history that Lance just described for us and to remind ourselves of what the objectives were in this renegotiation. And there were different objectives for different segments of our government. For the Trump administration, if you listen to the president's rhetoric, Ambassador Lighthizer rhetoric, was very much focused on fixing the NAFTA, that the NAFTA had led to a substantial imbalance in the trade relationship, in particular between the US and Mexico, and that this needed to be remedied. Along with that, there was some rhetoric as well, especially among Republicans in Congress, that, well, after all, the NAFTA is a 20-plus-year-old agreement and it could use updating. I think that if you ask any Democrat, in particular Democrats in the House, about the renegotiation of NAFTA, that the House Democrats looked at this exercise as an opportunity also to fix some of the fundamental flaws in the original NAFTA. And this goes back to Lance's rendition of the history in terms of the Clinton threading of the needle to address concerns around the terms of competition for labor standards and environmental standards when you were going to knit up Mexico into this customs union, essentially, with Canada and the United States. So if you fast forward then, what I would say is that for the Democrats who retook the majority in the House in the 2018 election coming into 2019, we were presented with a concluded deal that was negotiated between the executives in the US, Canada, and Mexico. And in the Democrats' review of this agreement, there were particular concerns with the with where things had landed, and the desire and the feeling that the improvements had not been made to a sufficient standard that the House Democrats were willing to sign off on a renewal of the agreement. And you'd see that the areas where Democrats wanted especially to ensure that the very high bar for renegotiation were met were on labor and the environment, and on enforcement and enforceability. And then an additional element that has evolved as our trade policies and trade agreements have evolved on access to medicines. So in that backdrop, what I want to highlight is through this renegotiation of the USMCA between House Democrats and the Trump administration, a number of enhancements, significant enhancements, were incorporated into the USMCA. For today's purposes, we will focus on the enhancements to labor enforcement and the labor monitoring mechanisms. And I want to reiterate the high bar for the renewal of a NAFTA agreement for a caucus and a community that felt like the trajectory of the NAFTA played out exactly as they had predicted in terms of where the NAFTA had failed. And speaking for the House Democratic view, and I think that this will be differentiable from the administration's view in terms of the flaws of the NAFTA, but I think that primarily the problem with the original NAFTA is that it promised increased and improved prosperity for the people of North America, and it had not delivered on that. in particular here in the US and in Mexico over 20 plus years of the NAFTA agreement, what we saw in trends in the US and in Mexico were increasing levels of productivity for the workers that were being met with decreasing adjustment for inflation, decreasing levels of wages and benefits, so that over time we see that the workers in both countries have been left worse off, certainly than we had promised. We had been promised that they would be, but potentially worse off than where we had started. And so the desire in this renegotiation between the Democrats and the Trump administration was to inject the new agreement with belts and suspenders and more belts and suspenders to secure the kind of positive change, to incorporate the terms that would be most beneficial, most likely to bring about the kind of inclusive prosperity for Americans and for Mexicans. So the main components, there are actually a lot of new components in the USMCA. Some of them are built into the agreement text. Many of them are built into the domestic implementing law here in the U.S. And I think it's worth being covering the full landscape to be aware of all of the moving parts. Obviously, I think one of the headline features that has gotten a lot of attention is the mechanism spelled out in Annex 31A. So this is supplemental to the state-to-state dispute settlement function that was in the original NAFTA, but which in the original NAFTA did not reach the labor and environment provisions. Now those state-to-state, that state-to-state mechanism does cover the entirety of the labor and the environment chapters. But in addition, you have a labor-specific enhanced enforcement mechanism. We call it different things. For our Senate friends, we will call it the Brown-Wyden mechanism. It's also called the rapid response mechanism. I'll try to settle on something that's easy to roll off the tongue for the purposes of this conversation. But I think that what's really novel and to highlight in this mechanism is that, first of all, it remains a state-to-state function. In its nature, it is still a state-to-state dispute settlement mechanism. What is, however, really special about this is that it focuses on facility-specific violations. So unlike the claims that have traditionally had to be brought for labor under a state-to-state rubric, those claims have generally been required to show persistent failures and a pattern of abuse. In the case of this mechanism, the scope goes to violation defined as a denial of rights relate to freedom of association, the right to collective bargaining at a specific facility. And in a set of sectors that are specifically covered by this mechanism. The other thing that I want to highlight in terms of this mechanism is the threshold that's defined for activating the mechanism. The term is a good faith belief, that one party needs to have only a good faith belief that rights are being denied at a specific facility in order to invoke the mechanism. So that is very deliberately established using these terms to overcome one of the legacy issues with dispute settlement under our trade agreements, which is that the threshold is so high that problems often do not get resolved using the mechanisms that are available because the internal assessment process, the process for starting the case, requires such a high threshold for demonstrating already that violations have occurred. Here it's simply on the basis that there is a good faith belief that rights are being denied. And then if you will look at the structure of that mechanism, there are a couple important components. So each country has the right to request that a review be done at the facility in question related to the violations that are believed to be occurring. There is a process for consultation. There is a process for remediation. And all along the way, the two parties, the complaining party and the responding party, must be in communication with each other about the next step. So at any point where there is a disagreement about whether or not the problem has been solved, there is a path to requesting a panel under this mechanism. With respect to the panel, it's envisioned as a 3-person panel. One person would be selected from the list of one party, the other from the list of the other party, and then there is a third joint list from which the third panelist would be selected. And that where there are disagreements about whether or not violations are continuing, that those panelists then have the right to make a verification of what is actually going on the ground. And on this, I think it's maybe useful for folks to know that this type of a structure has precedent in U.S. trade agreements, and that if you look at the U.S.-Peru trade agreement, there is a enforcement mechanism that is specific to logging and forestry that is built into that agreement that also has a request verification determination process that is built in there. So with respect to the verification then, the panelists is envisioned will be empowered to themselves investigate what is happening at the facility to verify whether or not a violation and denial of rights is occurring. If there is a determination by the panel that a violation is happening, there's obviously an opportunity for the parties to agree to a course of remediation where that remediation doesn't resolve the problem, or there is no agreement around the course of remediation, then there is a right to the imposition of remedies. And this is another area where this specific enforcement mechanism is quite unique in terms of the remedies that may be imposed. It can be quite broad. It would include the suspension of benefits, and in trade speak, that generally means the imposition of tariffs. But in really egregious cases, it kind of like a 3 strikes for an offending facility or family of facilities. Goods could be blocked at the border. And I would draw everyone's attention to the fact that in terms of the sectors that are covered by this mechanism, it is not limited to the traded goods sectors, but it also includes services sectors. And so with respect to remedies imposed for violations occurring in services, I think that there will be a very interesting question around what an appropriate remedy for a violation in services sector would look like. That's in terms of the enforcement mechanism, which is getting a lot of scrutiny, a lot of attention, rightly so. I would note that in conversations with counterparts in the Mexican government, that some have expressed the view that a successful functioning of the USMCA is for this particular labor enforcement mechanism to never be invoked. And on that, I wanted to share, since I'm speaking off the record, that not only for myself and those I work with and for, but also for some of our business community stakeholders. There's very much here in the US the view that successful USMCA is one where this mechanism is invoked and in fact leads to positive change on the ground at facilities in Mexico for Mexican workers to improve their standing with respect to their exercise of their freedom of association and their rights to collective bargaining. So I want to emphasize that this mechanism was very much negotiated and memorialized with the intention that it be used and that it be used to support the labor and labor justice reforms that have been undertaken by Mexico and are underway and being implemented in Mexico. And I would say that our hope is very much that through Mexico's own domestic politics and dynamics, and through the use of this mechanism, that we will see the kind of positive change in Mexican labor relations that allows for the USMCA to facilitate improved, more inclusive prosperity in Mexico and in the US. So I don't want to go on for too long, but let me just flag that in terms of the monitoring functions, that I would draw people's attention to the implementing bill, the creation of an interagency labor committee with a number of responsibilities, including the creation of a hotline for anybody, but including workers at a facility, to report abuses and potential violations. For this interagency labor committee, that it also has a responsibility for receiving petitions that may come from anybody to petition for action under either state to state or this labor-specific enforcement mechanism. The committee is also responsible for an ongoing assessment of Mexico's labor reforms and Mexico's implementation of those reforms, measured against the benchmarks that the Mexican government has spelled out for itself. And that all of this culminates at the 5-year mark with a comprehensive assessment of Mexico's implementation, with the view that this assessment will feed into the 6-year performance review for the entire agreement, where all 3 countries must come together to assess their satisfaction or dissatisfaction with the implementation of the agreement and decide whether or not to go on. My last point quickly is that the implementation of this was so important to the House Democrats. There's a large part of our focus, and for my chairman, a large part of his conversations with President López Obrador went to Mexico's commitment of its budgetary funds to support implementation of its labor reforms at home in Mexico. But I also want to emphasize that for the House Democrats, it was important for the U.S. to put its own money on this commitment and to invest in the support for Mexico's labor reforms, and that there is $210 million that are committed by the U.S. government to dedicated to supporting labor reform and labor enforcement under USMCA, and that over about half of that is intended by my committee's Democrats to go to worker training and education of workers' rights in the workplace in Mexico. So I apologize if I've run on for a little bit there. I am eager to hear the other panelists as well, and looking forward to taking questions. Thank you all.
Thank you, Katherine. And now I'm going to give the mic to Patricia Juan Pineda.
Okay, hello, good morning. Thanks for inviting me. My English is very bad, so I will try to do something with this. I have 3 questions. The first one is, what are the main challenges to implement the reform of Mexico labor law institutions Because the short time, I will say just items, just ideas, because I think it's not easy to explain all the situation in Mexico. We have many contradictions with the new government, and it's a little bit difficult to talk about that, and it's too much time for that. So the first one, the protection contract, that the 90% of the collective bargaining agreement in Mexico, that is a strong force in the federal and local labor institutions and workplaces. It won't be easy to change that. Imagine in all the country, all this force of these mafias of unions, employers, and governments to improve in this model, and they don't want to split it. They don't want to destroy it. They don't want to cancel. They are enforcing now. On the other hand, we have a long task with the harmonization of the national and local law, because with the international labor and human rights. What it means, the federal constitution changed in 2011. Now we have international law in our domestic law, but the states in the country doesn't change that and doesn't accept that still now. What it means is the conventions, ILO conventions, is not in the constitution, it's not in the law, it's not in the practice of the states of the country. Imagine that situation in the north border, our north border, and in the cluster in the center of the country. If we don't have the same vision, interpretation of the laws, national and international, we can fix and we can implementation the new law. Other problem, Katherine talked about that, the money, the budget for implementation. The budget necessary for the implementation in all the country is not enough, because much of it is for the priority projects like Maya Train and those Vogt refineries. So the money for the implementation of the labor reform is not there. It's just a little. In this year, we're supposed to start with the first 10 new labor tribunals, but the pandemic and the budget and the crisis economic, we just start with seven tribunals, the smallest in the country. So the other phase is the economic austerity politic that threat the present and the future viability of the federal and local institutions. Can you imagine the labor secretary doesn't have money for computers, we don't have inspectors, we don't have lawyers. The Federal Conciliation Arbitration Board, CDA, is lack of paper, we don't have lawyers. The workers there are the young people from the program, Youth in the Future, something like that is the name. So how can we think the access to justice and the finish of the work from the CBA is in the hands of these young people, and we don't have people to do resolutions, to have the hearings day by day. We don't have people in the hearings. So it's hard to think about that. The protection contract model and the partners of this corruption chain take advantage in this transition process, because the new law will be in the total operation in 2023. So they are reinforcing the control of the collective bargaining agreement using the structure in the federal and local CBA. They still sign protection contracts. We are very, very angry because we know, we listen, we are checking this situation. The government are still signing this protection contract in the Maya Train, in those Vogt refinery, and in other companies. They are setting in the cluster in the center of the country and in the north border. So it's like we can't believe this contradiction, because we have to change this kind of model. But on the other hand, they are still signing these protection contracts. The corruption unions like CTM, and now we have a kind of new one. It names CATEM, C-A-T-E-M. It's the worst phase of the CTM. They have a long story in the Estado de Mexico. So this group, the CATEM and CTM, now they are the new partner from the new government. The only cases that the president stay with workers in some public situation was with the CTM and the CATM, the CATM. So he wasn't talked with independent unions. These kind of unions, the independent, are discrimination in the local and the level situation, in the decisions, in like pensions, like outsourcing. We are excluding completely from all that discussions because the mafia of the employers, union, and authorities keep control on the labor and criminal situation. You know, maybe you know, the last July we have a detention of a lawyer. She was the advisor from the workers in the north frontier, and the last week we have a detention of another general secretary because he has a demonstration for wages. He just have a demonstration because he wants the government pay their salary, the benefits, and he's now in jail. So we can understand how we can talk about freedom of association, the implementation of the new law, when the criminalization of these situations are still working in the country. The employer's strategy to avoid the labor contracts, like change the production company and services for move to the local level. It is working too difficult because many times the producers from tires, now they are services, so they don't they don't use the labor law, the new labor law. They don't use the new institution because now in the local level, they have a big and corruption mafia, so it doesn't work really. And now the workers don't have the protection and doesn't have the visibility to this protection. You know, the other way they used to avoid the new labor laws, dissolve the employer in obligation with different names, outsourcing civil or commercial contracts. The result is more and more protection contracts within security jobs in all the country. So I repeat, how can workers organize in new or other unions, independent unions, if they don't have security jobs, if they don't feel free to struggle for their rights because of criminalization. Many workers, in the other face, the good news, workers are very happy and they trust in the freedom of association, the speech of the government. So we have a really strong movement around the country. Many workers try to know their rights, try to know the new law, try to know and understand how can they exercise and feel and work with the freedom of association. It means a lot of work in all the country and the small towns in the country, the big cities in the country. But it's also another challenge in this phase because the independence unions need a strong to be there, need a strong to help them, to advise them, and have the lawyers to do the work for change these corrupt unions, the new unions, to fight for their rights. I hope it's good. Okay, the second question is, what are the potential effects of the new USMCA? I prefer to say the MEC, in Mexico we said so, mechanism, and the labor reform in Mexican workers' company. In Mexico, we're clear with something. When the discussion of this trade agreement, many of us talk about it's not good because the NAFTA wasn't good for workers because it means a lot of, we lose jobs, we lose wages, we lose benefits, and the violence of the protection contract was enforced with this NAFTA, and now we feel a little fair with that. So we know the trade agreement is a trade agreement. It's not for workers, it's for the goals that protect the profits and merchandise. Just read it, and one tactic the tactic for this is cancel social dumping with Chapter 23 and Chapter 31 with the Annex 31A and 31B. Because Mexico attracts investment with low salaries and control workforce for one, that is the reason of the protection contract. If you have workers under control, workers without unions, independent unions, you can do more. Sorry, I forget the word. Sorry. Okay. The jobs are worse. in the way you are more and more cheap. You can control the workers. So that's the real vision we know about the trade agreement. So what we think about this new system? We think to monitoring together all time the companies for detect labor and human rights violation. Since the beginning, when a company announced they will set in the country, we need to know what are they going to do, because they signed the protection contracts since they make the announce. So we need to stop that. We really need to stop that, because we don't want new protection contracts. We need to follow this company in all the time, because during they are working, they are using this kind of strategies to avoid the labor law, to avoid the labor contracts, to avoid the laws in the states, and the mafia is still working. So we need to face that. We also think this new tool for unions and workers, we have to learn to manage and articulate with US and Canada union inequality. That's very important for us, because many times for workers, when we think the unions from USA and Canada are here, it's important to talk together the way to build together the strategy, to build together the way to learn, to work, to manage all the process. The international net was really good. It was very important for all the process in the NAFTA, but sometimes the Mexican workers doesn't know what really happens. This time, we really want to be part of this. We really want to know what will happen. We really know the principal part of this, because in the way we work together, we protect our jobs, we protect our wages, we protect our benefits. So we think it's important for us to work together in equality conditions. The third question, can we expect tangible effects short-term or middle-term? Even all the situation, even all the contradiction in the government, Mexican government, and all the spread of the information and the situation of the workers in Mexico, I'm optimist. If you are union, if you have to be optimist. And the new goal, the objective of the objective of the new law is eliminate the protection contract. If we don't lose that goal, if we don't really lose, we know first, really cancel all the protection contract, stop that mafia, stop the vision of the control of the workers, stop the vision that the government have about the workers, because even including the new government think you are with me or you are against with me or you are against me. So we need to change that vision, because if the workers doesn't receive the information, doesn't feel the respect of their rights, it will be a problem not so far, because the workers are very angry. They don't receive the lawyer. They don't receive their salary. Time by time, they're losing more and more benefits. So we need throw the mafia from the economic. I know they are the owners of the money. We know they are the owners of more of the investment. They are the owners of the investment in Mexico. We know each investment in Mexico have rules for protect this investment, but we really hope find a way to stop these abuses of the investment, because in the way they have the control of the money, in Mexico have the risks for problems. So we think more about that. In the labor law-making body structures, we have deputies and senators. They don't want to change this. So the law is not working so good. The implementation is so good because we have another laws around this law, around the labor law, and it's not respecting the rights, the labor rights and the human rights. So we have fights in the deputies with senators, like the discussion of outsourcing. We need to stop the outsourcing. What else? Now in Mexico, we're using too much a phrase because a writer, he said something like the dinosaur. When we wake up, the dinosaur was still there. In Mexico, it's like that because now we have a new law. We have the hope to change this. We have a new constitution with new labor rights, but the mafia is still there. The control in the states and the control in the federal government is still there. They are still ruling the CBA, ruling the Supreme Court, ruling the deputies and the senators. So we really want an effective exercising of freedom of association, a collective bargain. We really want no more protection contracts. We need to stop the chronic impunity. If we don't investigate the past abuses and report the damage caused to the victim in this present, the future will repeat the same mistakes. So we have to be alert in that vision. Thank you.
Thank you, Patricia. And next we have Jeff Vogt.
Thank you very much, and I'll be briefer, I think, because we're running a bit out of time. And it's great to obviously follow three excellent presentations, which I'll just try to really add a little bit to what's already been said. And the primary question that was posed to me is, will U.S. workers benefit from the USMCA? And I'll also footnote that I'm speaking individually here, not on behalf of any particular institution. But I think we need to look at it in three different ways. One, we'll just take a look at the labor chapter itself, but I think we also need to have a wider view of the trade agreement as a second lens. And then third, obviously, is looking at U.S. domestic policy, which is directly related to this, and so far not really part of the discussion. So, will workers benefit from this? I think one part of that is answered obviously by will Mexican workers benefit from this? I mean, since NAFTA in 1994 and the U.S.-Canada before that, I mean, there has been a kind of transnational dialogue between the unions of the three countries, and I think a recognition that no one particular worker or union will benefit unless all are able to exercise their fundamental rights. And that was in part what gave rise to the labor side agreement, the NALC of the original NAFTA agreement. And I think what Patty has mentioned here, does underscore that there are still significant concerns in Mexico, even with the adoption of important constitutional reforms, very important reforms to the labor code. There remains still a number of issues with the administration of that law, the implementation of that law, and the enforcement, which still needs to take place. It was just a few days ago that a contested, a contest over a protection contract at PKC under the new laws resulted in a finding in favor of the protection contract union. And as Patty was also mentioning, there still remain the problem that with the review of existing protection contracts, what we're seeing are new protection contracts being validated to replace old protection contracts. So I think we still see, significant risks. Important steps forward, of course, but still important risks as to whether the new labor law will deliver on kind of expectations of both Mexican workers, U.S. workers, and Canadian workers. The USMCA per se itself has not been tested. Of course, there are discussions now about the filing of potential cases under the rapid response mechanism. These are still in very initial stages, and we will see then to the extent to which the rapid response mechanism, as Katherine was describing, is able to provide targeted relief to workers in a particular covered factory. I think the labor chapter of the USMCA certainly overall has improved, both the labor chapter as it pertains to these kind of broader challenges between states, as well as the rapid response mechanism. I mean, they all reflect improvement. Some of them pick up on some of the innovations that were included in the Trans-Pacific Partnership, as Alvaro mentioned. I think much of what we see in the USMCA is a direct response to the failed arbitration under the CAFTA agreement and the US-Guatemala dispute. So we see the review of what manner affecting trade means to be one that is much easier for workers to use. There are, I think, still some definitional issues with regard to the labor chapter, but it has certainly improved. It recognizes anti-union violence explicitly, which has always been something that there has been a fight as to whether it's been something included under the labor chapters. It makes a direct reference to the right to strike, which is important, particularly with what was happening at the ILO at the time. So I think there are possibilities that the USMCA's labor chapter and rapid response mechanism will help contribute to improvements in Mexico. I think when we look to see whether this may be a mechanism that's useful to challenge the US, I think it's slightly a less optimistic story. The rapid response mechanism has language which provides that it really can't be used in facilities where there's not an enforced board order of the National Labor Relations Board. An enforced board order typically is when you have a board decision supported by the Court of Appeal, the Federal Court of Appeals. So we have a much higher hurdle to be able to use the rapid response mechanism in the US than you would have in Mexico. Countries have been, outside of the NELC, have been reluctant to bring FTA claims against the US. And outside of the NELC, there hasn't been a claim against the US under any FTA I'm aware of. And even, when it's obvious that I think U.S. labor law does not comply with the 1998 declaration, countries, our negotiating partners have been reluctant, with some exceptions, to raise concerns about U.S. labor law, with actually South Korea being an exception to that. So, whether the labor chapter is going to have a direct impact on U.S. workers, again, I'm certain that the AFL-CIO and others will test this mechanism out to see whether it is, in fact, useful in the U.S. context. But I think there are some limitations to be mindful of. There's also, importantly, this rule of origin amendment that was made that would require a minimum of $16 an hour being paid to workers in Mexico, in certain sectors, with the idea that this would perhaps shift some employment back to the United States. I think this is probably unlikely. And you're hearing even from some other kind of automakers that they would, in some sense, rather pay the $16 an hour and invest in Mexico than in the United States. So it's very obviously the potential increase in wages in Mexico is important. Whether this will rebound back on the United States workers is a question. I think we put it in the wider view of the agreement as a whole. The USITC's report in 2019, looking at the overall impact of the FTA, found that it would really have a quite minuscule impact on U.S. employment. And even that was, I think, making a lot of aggressive assumptions about the benefits that would flow from certain regulatory changes. So it's not clear whether this will be a real job creator for the United States, or that those jobs will be necessarily jobs with decent work. I think they're also looking at other parts of the trade agreement. There are other parts that have others have remarked on that I think are interesting to note. The trade unions have always raised concerns with regard to the investor-state dispute settlement. That has been addressed in part. It will phase out between the U.S. and Canada in 3 years, and it still remains with regard to certain sectors between U.S. and Mexico. But trade unions, if you look at the reports they've submitted with regard to every FTA that's come up, there have been significant concerns with regard to the regulation of government procurement, services, medicines, financial deregulation. So that there's, the FTAs, as Lance mentioned at the beginning, I think in putting aside the labor provisions, were an attempt to kind of lock in neoliberal reforms at the time, and that this still is largely the goal of the FTAs, as Patty mentioned. So I think if you look at the wider view, whether U.S. workers will benefit will also is still a question. And again, even aggressive predictions of job growth under U.S.-Korea never materialized. In fact, there was a growing trade deficit with the country. And I think the last point I would like to make is around U.S. domestic policy. I mean, without the complementary domestic policy, we can't expect trade necessarily to also provide a particular benefit for workers in the form of employment growth and better wages, better working conditions. As I mentioned, and I'm sure any labor lawyer on this webinar can attest that the U.S. labor law is in serious need for reform. There are vast exclusions of workers from even basic protections under the National Labor Relations Act, whether they're domestic workers, agricultural workers. at least in the United States, most gig workers are treated as independent contractors, while that is changing actually in much of the rest of the world. Workers who are in particularly high risk now under COVID or have some of the least protections. It's been mentioned before, the stagnation of U.S. wages, which really will only, I think, be addressed if there is significant reform to the laws governing collective bargaining. And I think, as we've seen over the last couple of years, there's been a strong push by unions to put the idea of a sectoral collective bargaining onto the agenda. And I think that's a critical reform. And then, the one measure that's been used to offset the job losses or the job displacement because of trade, the trade adjustment assistance, I think is widely understood to be insufficient, with the, over 1 million workers who lost jobs, including union jobs in manufacturing with collective bargaining agreements. Many of them were not in a position to find other jobs that use those skills. They were, many of them went into training for much lower wage service jobs without collective bargaining agreements. So even with those who were able to establish a trade impact and able to get into a TAA program, the outcome for individual workers was quite negative. So really having active labor market policies in a real fundamental way, I think, is absolutely important to ensure that those who may be impacted directly by trade will have some means to get into better work, and that the U.S. And other countries have an active industrial policy. And this has also been an area where critics have noted that the ability to undertake robust industrial policies have in some ways been undermined by the FTAs themselves, whether it's subsidies or the use of government procurement for domestic employment strategies. So I think we need to, again, take a look at the whole of the labor chapter, its possibilities, the broader FTA itself, and the potential changes to U.S. domestic policy to see whether this will actually, in the end, be an overall benefit to workers. So I will leave it there because I think we only have 15 minutes left for questions. And thanks.
Thank you, Jeff. Thank you to all our speakers. You brought really important insights on different parts of the puzzle. So even though there's these improved mechanisms in USMCA, there are many questions remained about how effective they will be for the purposes that they were announced in terms of really improving conditions of work in Mexico, having effects that could be positive in the United States. And I think all of you more broadly have also pointed to broader dynamics in which these free trade agreements are inserted or participate. And so to what extent countries are going to be able to undertake policies that create jobs and make those jobs be well remunerated and with good conditions remains an important question. But let me, I have already a number of questions, and so let me pose them to you. The first one comes from Sean Hagan, who's a professor at Georgetown, and he was formerly the general counsel at the International Monetary Fund. And he asks, after the description of the new USMCA mechanisms, doesn't this new feature further illustrate the need for WTO rules to be revised to address minimum labor standards? While this arrangement helps Mexico with the US, it might make Mexico less competitive with other countries that have low labor costs. So a concern here of regulatory competition and what this may make Mexico in comparison with other low-wage countries. Who'd like to answer that question?
I'll take it on quickly.
Right.
I think the short answer is yes. In principle, it would be great if these types of labor protections could be universalized through the disciplines of the WTO. Practically speaking, I don't see it on the agenda very soon. The WTO is itself in some amount of turmoil and disarray, the WTO has always resisted the idea of a social clause or a trade labor linkage. They've always been dominated by, deregulatory oriented economists and policymakers. So I think in principle, it would be great if the WTO could move in this direction, but I don't see it happening soon.
Okay. Thank you. Let me pose another question. This is from Amara Lee, a journalist and reporter at the International Trade Today for Jeff. Richard Tromka said we should expect a rapid response mechanism complaint within 30 days back in late September. Has the AFL-CIO filed such a complaint? If so, when might that become public? If not, do you think there will be such a complaint filed in 2020?
I'm going to have to dodge that question a bit. I'm not here representing the AFL-CIO. There has not been a complaint filed yet, but whether and when that will be filed, I can't answer. Sorry.
Then another question for you, Jeff, also from Mara Lee. You mentioned there have been some new protection contracts validated to replace the old protection contracts. Were those new contracts approved by the necessary fraction of workers? Do the workers know what wages and job protections or benefits are in those contracts? Are the contracts more generous?
Pati is probably in a better place to answer this, but I'll tell you what I know is, from what I understand, there has been a validation process. If there have been some cases where workers are said or told, okay, you have a CBA, right? You have to vote now on this agreement, and this is not done in the context of organizing. This is not done in the context of workers being aware that there are other options available, that there are other unions they could belong to. And in fact, in some cases, they're being told that if you do not validate the agreement you already have, then you have nothing, which is not actually, it's the contrary in Mexican labor law under the newer forms, but it's not being explained to them that way. So I think you have some cases of contracts being validated with workers in the misbelief that if they say no, that they have nothing, when in fact they could say no, still have the same benefits that are under the agreement, but then seek to form their own union or belong to some other union. So I think it's the problem of the validation process taking place in where protection contract unions are still extraordinarily dominant and the alternatives are still very small. And in that scenario, I think it's natural that you're seeing old contracts just renewed and being validated.
Let me see if Patty wants to jump in here to talk about these new protection contracts.
The big industry is using a strategy, very aggressive. I will use example. Teresa Medina, the leadership from the automotive industry in all the country, he has the protection contract in Ford and some others, I don't remember who else. But it's an expensive, even it's a protection contract, it's an expensive contract because it's an old contract. So the company decide we want change this because we want the workers are cheapest. low wages and low benefits. So the company changed the name and changed all the legal vision and the legal and tax situation. Now it's not example 4. Now is the whatever. It was an automakers. Now it's an industry of services. So this mafia, this union, come to the company, harassment, attack the workers. If they don't sign to quit the company, to get quick to the union, and now you have to sign another contract, a new contract with worse conditions, with worse salary, a contract with the new company, the new CBA. So now this new company, the new protection contract is legalized and is working. So it's one of the strategies, and it's incredible, because we announced that to the government and nothing happens. Really, nothing happens. This is one way, one strategy. The other strategy is the new law. We named the protocolo I will try to introduce something like protocol to legitimize the CBA, something like that. What it means, it's a trick, because the union, the corrupt union, said to the labor secretary they will have a vote to decide if this CBA is legitimized or no. But the workers doesn't know what are they voting. The labor secretary, the inspectors never check if the workers have the information for that. They just go and see if the workers vote free and it's secret ballots, stuff like that. But they don't check if they know the information. So the workers vote for this CBA, but they doesn't know. They are really voting for the union, the corrupt union. They are ratified the corrupt union, because they don't lose the rights in the CBA if they don't vote for this. Let
me stop you there, Patty. Thank you. So I want to ask a question, and obviously I understand this is complex and it has many moving parts, as we heard from the different speakers. There remains a huge issue of how the labor law is going to be implemented in Mexico, and Patty has raised some of the challenges. But even within the narrow framework of the new USMCA mechanisms, one can see a really noticeable asymmetry, particularly in the rapid response panels and the way they're supposed to operate. Katherine and Jeff referred to these mechanisms, but I'm also curious about what Lance thinks. This was a really good opportunity for the labor union, for the labor movement in the United States to basically make this reciprocal in that just as Mexico was going to be subject to these mechanisms, the US workers could benefit from these new enforcement institutions. However, we see an asymmetry in terms of exhaustion of local remedies, right? That I believe Jeffrey mentioned. So in the US, it has to be an enforceable order of the National Labor Relations Board. That doesn't exist in Mexico. There's also only a limited number of denial of rights that can be reviewed. So freedom of association and collective bargaining, but not the other labor rights that are contained in the agreement. And then there's also specific priority sectors, including manufacturing, services, and mining. So this leaves out entirely agriculture, for instance. Lance brought us sort of up to speed with what had happened during the NAFTA agreement. And what we saw were a number of complaints against the US for problems with enforcing workers' rights in the agricultural sector. So one question is, why not take advantage of these mechanisms to basically make them encompass the problems that we had observed with NAFTA? It seems like it was designed to actually, in some ways, go around them or protect the enforcement in the US of the problems that had arisen from NAFTA. And that is puzzling because it was a brand new opportunity to address these questions for both Mexico and the United States. So I wanted to see what your thoughts are on that question.
Alvaro, if I could jump in
Katherine,
on
please.
this.
Yes.
Okay, sure.
Yes, please.
I would say this, if it's not contradictory, that what you see in the rapid response mechanism in particular is both a quantum leap in terms of evolution of our trade tools, but also part of a longer trend of incremental progress. So I can attest to the amount of blood, sweat, tears, breakdowns that went into the negotiation to create this particular mechanism. It was not easy. On the part of the US government, on the part of the negotiations between the countries, I know. But what I would also say is that this is not a complete evolution, right? It's an important step. And I just thought I would return to the question about the WTO. I think that's right. I think that there is further evolution and progress that can be made here. The first test, I think, here is whether or not this mechanism can be demonstrated to show that it can bring about positive change and progress. I very much hope so. And I think that from there, there is a lot of opportunity to think further about how to use these mechanisms to really deliver on a promise of more inclusive prosperity. On the WTO point, I just wanted to make one last reference, which is when the question was posed, I was reminded that at the very, very beginning of the WTO agreements, it's the Marrakesh Agreement establishing the World Trade Organization. This is kind of like the frame for all of the individual agreements. It starts, literally the first words say, the parties to this agreement recognizing that their relations in the field of trade and economic endeavor should be conducted with a view to raising standards of living, ensuring full employment, and a large and steadily growing volume of real income and effective demand, and expanding the production of trade and goods. I just want to frame and push back on the idea that labor provisions in trade agreements are social issues that don't belong in the trade agreements. Our trade agreements have become very, very comprehensive trade, investment, economic agreements. If labor and the cause of thinking about the people who are involved in the economy, not just as consumers, but also as workers. If that doesn't have a place in the WTO, I think that the WTO doesn't have a mission, and I think that's undermined by the agreement itself that starts by framing the purpose of the entire organization and the agreements around this idea of raising standards of living and improving the lives of the people in the countries that are members.
Thanks, Katherine. Let me see if another member of the panel wants to jump in. We're gonna close soon because we're out of time. But if someone wants to say something, this would be a good moment. Thanks. Lance.
Well, just on the last question you raised, I think it was something of a missed opportunity to, particularly with respect to agriculture. But don't forget, there's a lot of attention given to the rapid response mechanism, but the normal complaint mechanism still remains in place, and it is still possible to bring complaints on behalf of migrant agricultural workers in the United States for violations of their rights in the United States. A complaint could be filed with the government of Mexico or Canada on their behalf. That there is a procedure for that, a dispute like that, ultimately reaching dispute resolution and arbitration.
Thanks. All right. Well, so this, it's very exciting in terms of the opportunities that this could open up, and just following up on Catherine's last comment, it's a test, it's an experiment, and we will see if this manages to also percolate or have effects in how we think about future trade agreements and whether this will have an impact or not also at the multilateral level. I want to thank you all for joining us today and for sharing your insights and your experience with us. I want to also thank our audience for connecting today, and I want to remind you that we have a career paths session on transnational labor law this Thursday. That's a companion of this webinar in the model of international and transnational labor law. Thank you again to our panelists, and I hope you enjoy the rest of your day. Bye-bye.